All right, so contingent workers. I will tell you that in the 2000s, when the use of these temporary, part-time, sporadic workers increased so dramatically, many employers hired these workers as independent contractors. It seemed like a good way to distinguish between those full-time employees and those temporary workers, and it saved the employer from having to deal with withholding, having to deal with all the cost of an employee while achieving the same benefit. And again, employers were willing to pass on these cost savings to the independent contractor. So an independent contractor could be making more money than the equivalent employee. But unfortunately, when that line began to blur between who is an employee and who is an independent contractor, employers got skittish. Employers became concerned that these workers, these independent contractors, could be construed at some future date by some court as employees and not independent contractors. And so they began to utilize really what had already existed, just on a much smaller scale, and that was the use of staffing firms. The staffing firm is the actual employer. So while the employee will work for one employer, in fact, that employee is not the employee of the employer, but the employee of the staffing company. The staffing company is the actual employer. The primary employer will contract with a staffing agency to provide a workforce, meaning that staffing company is going to take on all those administrative roles of the employer, and the employer, the actual employer, the primary employer, is freed from that responsibility. So we have seen a tremendous increase in the use of staffing agencies. We've seen it in the law, we've seen it in nursing, we've seen it in a number of areas wherein the employee works for a staffing company legally, officially, but does its work for another employer. So the staffing company will bear the burden of those regulations, especially having to do with the cost of withholding. And sometimes the staffing company may offer health insurance benefits or some sort of small retirement plan. That's rare, though. That's rare, and even rare that the employee will take advantage of that because of the cost involved. Now, in these staffing firm arrangements, however, the employer, the primary employer, must be careful not to exercise too much control over the employee, because ultimately the employee is the employee of the staffing agency and not the primary employer. So we have a situation where oftentimes a supervisor wants to give directions to a worker, but rather than being able simply to tell that worker what to do or what to not do, they must instead go through the staffing agency to pass on the message to the worker in order to establish that this worker is not the employee of the primary employer, but instead the employee of the staffing company. Now, if an employer does exercise that authority, the law is willing to find joint employment status. An employee may have two employers who are then referred to as joint employers. So even though you are officially, legally, technically an employee of the staffing agency, the same rules about control apply, and therefore you may also have an employer who is the primary employer. So the joint employment doctrine, it really says technically you are an employee of the staffing agency, but realistically you are an employee of both companies at the same time. So how do they determine that? Well, again, they look at a number of factors to determine which employer is primarily responsible for the work of this employee. And this is a very difficult determination. There's a huge gray area involved, but we have certainly seen cases in which employer courts and administrative agencies are more and more willing to find a joint employment status. There was a case out of California involving a waste management company, and the waste management company hired people to work at its recycling facility, and they hired two categories of workers. They hired the actual employees who did the recycling, but then they went through a staffing agency to bring on people to do the sorting of the goods before they went to the actual recycling. And those employees wanted to form a union, and the administrative agency here, the National Labor Relations Board, found in favor of joint employee status because of the exercise of control over the work of those employees. So, in conclusion, contingent employees, workers who work outside of the 40-hour norm, are called contingent workers. Make sure you know that word. Contingent workers, however, may still be employees, and as employees, they're going to be entitled to all of the protections that any other employee would have in terms of things like overtime, minimum wage, union organizing, all of those things, freedom from discrimination. And finally, know about this concept of joint employers. Two employers may be referred to as joint employers. And that's it. Thank you.